Assalamualaikum warahmatullahi taala wabarakatuh. My name is Muhammad Aidil bin Wan Zainul. So today I will be reviewing a case of public prosecutor versus RUTININ SUHAIMIN 2014. So first of all, I will be explaining a brief material fact about the case, what happened in the case briefly, and next I will explain the issue that has been brought up in the court, and next I will explain the holding of the judges, and we will see what happened to Mr. Rutinin and prosecution side at the end of the cases. And lastly, I will explain my own analysis and my own opinion about the case. So the case is quite interesting as it involved our Sultanate section and also Multimedia Act 1998. So I hope you enjoy my case review. Thank you. Okay, so let's go over the matter of fact. As you can see in the photo is Mr. Rutinin Suhaibin and his lawyer. So Mr. Rutinin was charged a fine of RM 15,000 ringgit Malaysia and 8 month imprisonment under Section 233 of Communication and Multimedia Act 1998. He was being accused of insulting Sultan Perak in internet. So what actually happened in the case? Okay, so what actually happened is the IP address containing information of Mr. Rutinin computer and internet connection have been traced back to the person who posted the insulting remark. The insulting remark sounds Sultan Perak sudah gila, which is Sultan Perak is mad. This IP address and MAC have been traced by Telekom Malaysia and the Perak Secretary Office, which is both an reliable evidence. So because of this, the IP address and the MAC number have been used to accuse Mr. Rutinin of the said offense. Okay, so in the case, I found three issues that have been brought up on the court, which is the first one, is it really Mr. Rutinin who posed the insulting remark, even though it has the IP address of his computer and a location of his shop? So the second of all, is the intent of the person really is to annoy or abuse the victim? And lastly, is the offensive remark itself really is annoying and abusive? So in the end of this case, Mr. Rutinin was found not guilty and has been acquitted by the judge. This is because the prosecution side has failed to establish a prima facie over the existing issue. So this is because, according to the case of Sunny Ang against public prosecutor 1965, it is stated that all of the circumstantial evidence must be very pointed towards the guilt of the offenders. If the circumstantial evidence didn't clear any reasonable doubt over the offense of the guilty, it is cannot be considered as an evidence that need to be taken heavily. So because of this, in the case, prosecution side failed to establish a prima facie over the first issue, which is it really Mr. Rutinin who accessed the computer and post the remark? The judges said that it could be a spoof or someone could tamper with the IP address. Because of this, there is a reasonable doubt, and that evidence of IP address cannot be considered as circumstantial evidence.